It began with a question that had lingered in legal circles for decades. Who really holds the reins of power in America? Congress, or the unelected bureaucrats that enforce its laws? On a quiet spring morning inside the marble halls of the United States Supreme Court, that question was no longer theoretical. It was on the docket. The nation's most powerful justices were set to hear a case that could redraw the boundaries of federal authority, a challenge to one of the government's most formidable regulatory agencies. And at the center of it all stood one woman, Pam Bondi. Once Florida's Attorney General, Bondi had made a name for herself as a fearless, tactical legal mind. Bold enough to take on high-profile cases, sharp enough to see moves others missed. But this was different. She wasn't just stepping into another courtroom. She was stepping onto the nation's highest judicial stage to question the very structure of administrative power. Representing a coalition of small businesses and policy think tanks, Bondi was arguing that the agency in question had stepped far beyond its statutory authority, that it had become a lawmaker unto itself, accountable to no one. Across the bench sat Chief Justice John Roberts, a man whose questions are as precise as they are unforgiving. Known for his measured tone but piercing logic, Roberts had earned a reputation as a constitutional purist, and today he wasn't expected to sit quietly. The stakes? Monumental. This wasn't just about one agency. This was about the framework of modern governance, about who interprets the law and who, if anyone, is allowed to stretch it. Behind the robes and the rhetoric loomed a confrontation that legal scholars would debate for years. And as the clerk called the court to order, all eyes turned to Pam Bondi. Because the battle that was about to unfold wasn't just legal. It was historical. The courtroom had barely settled before the storm began. Pam Bondi rose confidently, the justices arrayed before her like sentinels of constitutional judgment. With practiced composure, she began to lay out her case, a structured, deliberate challenge to decades of administrative interpretation. But she didn't get far. Chief Justice John Roberts cut in, swiftly, decisively. "Miss Bondi," he said, his voice calm but pointed, "your theory diverges sharply from our precedent in Henderson versus EPA. Are you asking this court to overturn an entire body of settled regulatory law?" It wasn't just a question. It was a warning. The room grew still. Legal observers had expected pushback, but not this quickly, not this forcefully. Roberts continued, pressing Bondi on the implications of her argument. "If we accept your view, Miss Bondi, are we not opening the door to invalidate decades of federal rulemaking? Entire industries operate under these standards. Are you prepared to say they were all unauthorized?" The weight of the challenge was enormous. The subtext was clear. Her position could upend the very machinery of modern government. But Bondi didn't flinch. She paused, met the Chief Justice's gaze, and nodded. "Mr. Chief Justice, I anticipated this concern." Her voice was even, unshaken. She acknowledged that Henderson had long shaped the court's understanding of agency authority, but then signaled, almost like revealing the edge of a sword, still sheathed, that what she had brought with her would reframe the issue entirely. "Our position," she continued, "does not rest on abstract constitutional theory, but on direct historical evidence, primary source documents that speak to the original legislative intent behind the statute at issue." There was a subtle shift in the air. She wasn't backing down. She wasn't hedging. She had come armed, not with hypotheticals or ideological arguments, but with something more powerful, facts from the historical record, the very heartbeat of legislative meaning. Roberts leaned back slightly, eyebrows narrowing. He didn't respond right away. It was clear to everyone in that chamber, Bondi wasn't just defending a theory. She was about to challenge the very foundation of the court's own assumptions, and this was only the beginning. What came next stunned even the most seasoned court watchers. Pam Bondi reached into her argument not for abstractions or broad constitutional principles, but for something far more unsettling to the status quo: historical fact. "Your Honor," she said, addressing Chief Justice Roberts directly, "the statute that underpins this agency's authority, the very one the federal government relies on to justify its sweeping regulations, was never intended to grant such power." Then she dropped the first of several exhibits, not charts, not summaries, but actual legislative transcripts, notes from Senate floor debates dating back nearly 50 years, handwritten memos exchanged between committee members, early drafts of the bill that showed, line by line, what language was rejected and why. "This isn't conjecture," she said calmly. "It's the legislative record. The words Congress chose not to include tell us just as much as the ones they did." She walked the court through the original framing, how key lawmakers, across both parties, had explicitly rejected language that would have given the agency the kind of interpretive leeway it later assumed for itself. The room shifted again. "Justice." Kagan leaned forward. Justice Alito raised an eyebrow. Even Roberts, composed as ever, tightened his jaw. Bondi didn't stop there. She moved next to internal executive branch memos from the agency's own general counsel's office, unearthed through a FOIA request just weeks before oral arguments. Memos that revealed deep internal debate over whether the agency had the authority it was now defending in court. Even they weren't sure, she said. And that was the moment the tide began to turn. This wasn't just about legal interpretation anymore. It wasn't about ideology. Bondi had reframed the entire argument. This was now about fidelity to the constitutional separation of powers and the danger of retroactively inflating congressional intent. Justice Gorsuch nodded slightly. Justice Barrett scribbled a note. Bondi's voice remained steady, precise, as she delivered her final strike in this phase of the argument. The framers of this statute understood the weight of regulatory authority. They knew the difference between guidance and governance, and they chose restraint. A silence followed, not out of confusion, but respect. She had turned a confrontation into a reckoning, not just with the agency, but with the court's own historical blind spots. And for the first time in the hearing, Chief Justice Roberts didn't have a response ready. What followed in the courtroom wasn't loud. It wasn't dramatic in the Hollywood sense. But it was seismic. Pam Bondi had laid her foundation, and now, without raising her voice, she began to build. Justice Elena Kagan, known for her razor-sharp intellect and unwavering defense of administrative stability, broke the silence. "Ms. Bondi," she began, "you're essentially arguing that the agency never had this authority. Not from Congress, not from precedent, not even from internal guidance. But if that's true, how do we explain the decades of judicial deference? Are we to undo an entire framework retroactively?" Bondi didn't blink. "Justice Kagan," she said, "judicial deference is not judicial surrender. When an error becomes systemic, recognizing it is not regression, it's responsibility." Her tone was measured, controlled, but every word landed with surgical precision. Then came Justice Brett Kavanaugh, a known institutionalist, wary of destabilizing doctrines, but not afraid to ask difficult questions. "You're asking us to reconsider Chevron, to draw a hard line between congressional silence and administrative expansion. Are you saying this court has been wrong?" Bondi paused just long enough. "I'm saying the court has been generous, and that generosity has outlived its constitutional purpose." Murmurs spread through the gallery. Even the government's counsel shifted uncomfortably. Then, for the second time that day, Chief Justice John Roberts re-entered the fray. His question wasn't adversarial this time. It was curious, analytical, almost careful. "Ms. Bondi, are you suggesting that if Congress had truly intended to grant this agency such sweeping discretion, It would have done so in unmistakable terms? Bondi turned her eyes to Roberts and replied, "That's precisely what. The Constitution demands, Chief Justice, not ambiguity, not inference, clarity." Another pause. This time, the chief nodded. Not in agreement. Not yet. But in acknowledgement. The balance in the room had shifted. You could feel it. This was no longer a hearing about a single statute or a single agency. It had become a referendum on how much authority any branch of government could borrow without being granted, and Pam Bondi, unshaken, unyielding, had forced the court to confront that reality. As the final minutes of oral argument ticked away, the room was silent except for the voice of Pam Bondi. She stood poised, steady, unwavering, not as a politician, not as a pundit, but as a constitutional purist making her last stand before the highest court in the land. "This case," she said, "is not about policy. It's not about politics. It's about power. And whether that power belongs to the people through their elected representatives or to unelected agencies with no direct accountability." She paused, just briefly, letting the weight of her words hang in the chamber. "If this court allows ambiguity to justify authority," she continued, "then we concede that vagueness is power and that silence can speak louder than law." It was not dramatic. It was devastating. "Chief," Justice Roberts looked up from his notes. He didn't interrupt. He didn't smirk. He didn't challenge her. He studied her, the way a judge does when he knows the record has shifted, when the foundation of his own jurisprudence has been directly and masterfully challenged. Then came the words, "No advocate forgets." "Thank you, Ms. Bondi." 3 seconds passed, then 5, then 10. No one moved. The air felt dense with something unspoken. Not victory, not defeat, but reverence. Roberts adjusted his glasses and leaned slightly forward. "We'll take this matter under submission." And just like that, the moment was over. But the silence that followed spoke louder than anything said that morning. For the first time, the justices, including Roberts, seemed less like a panel of skeptics and more like scholars reevaluating the pillars of administrative law. Pam Bondi stepped back from the podium, calm and composed, and walked past the counsel's table without a glance. Behind her, the echoes of her argument lingered, not as noise, but as a challenge. One that the court could not ignore, because she hadn't just presented a case. She had issued a call to reassert the Constitution's clarity in a world increasingly ruled by ambiguity. And John Roberts? He didn't say much. But that silence, that was the sound of a mind moved. In the days following the argument, legal analysts across the country scrambled to dissect what had just occurred in the Supreme Court. Pam Bondi hadn't merely argued against an agency. She had confronted a doctrine, one embedded in decades of judicial deference, and laid bare its constitutional contradictions. Cable news shows buzzed with speculation. Law school blogs lit up with praise and criticism alike. And inside the marble walls of the court, the justices began their closed-door deliberations. But outside, something was shifting. For the first time in years, the question of who really governs, agencies or the people, was not just academic, it was personal. If Bondi prevailed, entire regulatory frameworks could be called into question. Agencies would have to return to Congress for clearer authority. Ambiguity could no longer serve as a blank check. And Chief Justice John Roberts? He said nothing publicly. But court watchers noted something unusual in the days that followed, an uncharacteristic pause in administrative law cases on the court's docket. As if the justices were reconsidering more than just one case, as if the court itself had been challenged to re-examine its compass. For Pam Bondi, it wasn't about headlines. It wasn't even about winning. It was about principle. She had walked into the most powerful courtroom in America stood face to face with its most powerful jurist, and didn't flinch. She argued the Constitution not for applause, but for accountability, and whether the court rules in her favor or not. One thing is clear. She didn't just leave the justices with questions. She left them with doubt. And in the law, especially before the Supreme Court, doubt is the beginning of change. He interrupted her just minutes into her argument. Chief Justice John Roberts, sharp, unyielding, questioning her very foundation. Most attorneys would have folded. But Pam Bondi didn't blink. Instead, what followed was one of the most masterful legal reversals the court had seen in decades. This wasn't just another case. This was a reckoning with power itself. And it all began on a cold morning. Outside the Supreme Court. Pam Bondi's argument didn't just resonate inside the courtroom. It shook the pillars of federal authority across the nation. What started as a challenge became a legacy, and a reminder that history often turns on the courage of one voice, armed not with power, but with proof. If you found this breakdown compelling, don't forget to like this video and subscribe for more dramatic stories shaping America's legal future. Comment below. Do you think federal agencies have grown too powerful? Should courts do more to rein them in? And join us next week as we explore another landmark moment inside the halls of justice, where law, power, and principle collide.